Hi folks, it's Ryan Reed here from Reed Law Group. Today I want to address one of the most stressful and important decisions a co-parent can face after a divorce: relocating with your children. As a family law attorney here in South Central Kentucky, I often talk with parents who are considering a big change. Maybe it's for a new job, just a fresh start, or to be closer to family and support systems. The idea of moving with your kids can feel both exciting and overwhelming. I absolutely understand you have a right to build a new life for yourself, but when children are involved, it is not as simple as packing a truck and leaving town. Relocating with your kids after a divorce requires careful planning and a clear understanding of Kentucky law. The most important thing to remember is that you cannot simply move without following the proper legal steps. Doing so could have serious negative consequences, including potentially losing physical custody of your children. Kentucky law is very clear on this issue. If you want to relocate with the children from your current home, you must first give written notice to the other parent. This is a crucial step that applies even if you have sole custody. The law is designed to protect the other parent's rights and to ensure that the child or children maintain a strong relationship with both parents. There's no black and white line that says what kind of relocation qualifies. Some judges might expect you to provide the notice of relocation even if you're just moving in the same neighborhood. Another judge might not expect it unless you would be moving into a new school district. My sense, it's better to be safe than sorry, and file the notice of relocation anytime you plan to move. This notice should be given at least 60 days before your planned move, and it must include key details like your new address, the reason for the move, and whether the relocation will affect the current parenting schedule. The notice gives the other parent a chance to either agree or to object. If everyone agrees, the parents can often work together to create a new parenting schedule and submit that to the court for approval. But if the other parent objects to the move, and if they are a joint custodian, they have the legal right to do so, then the situation becomes a bit more complicated, and you will need to go to court to get permission. When parents can't agree, a judge will step in to decide. The court's primary and overriding concern in every single custody case, including relocation issues, is always what's in the best interest of the children. The parent who wants to move must prove that the relocation will be beneficial for the child and not just for themselves, and that those benefits will outweigh any detriments. You must also be able to show the court how the move will improve the child's life in a meaningful way. To make this difficult decision, the judge will consider a variety of specific factors. For example, the judge will look at the reason for the move. Is it for a better job that improves the financial stability of the parent, or for better schools, or to be closer to a necessary support system? The court will want to consider the impact on the child's relationship with both parents. How will the move affect the child's time and bond with the parent who is staying put? The court will want to see that the relocating parent has a realistic plan to maintain a strong relationship. Perhaps that's through extended summer visits or regular video calls. The judge will also consider the child's ties to their current community. This includes their school, their friendships, and any extracurricular activities. If those bonds are especially strong, the court may want to preserve them. The court will certainly consider the wishes of the child if the child is old enough to have a mature preference. Then in that case, the judge can consider what they want. And then the court will weigh carefully all of the relevant factors to decide if the benefits of the move outweigh any potential harm that it may cause to the child's life and their relationship with the other parent. Any decision issued by a judge after a hearing of this nature becomes binding and enforceable. And if the judge issues a new schedule, then that's what the parents would have to follow after the move. Relocation cases are some of the most difficult and emotionally charged in family law. My primary advice to folks is always to try to start by talking to your co-parent and working out a new, agreed-upon parenting plan if at all possible. If that's not possible, don't try to go it alone. It is critical that you seek legal guidance to ensure you follow the correct procedures. Moving without a court order can be seen as a violation of your custody agreement, and a judge could order the immediate return of your child to their home community and possibly even change the physical custody arrangement, even limiting your own parenting time. So it's always best to be patient, to follow the law, and to put your child's best interest first. and to work with an experienced lawyer who can help you follow the correct procedures to help you explore compromise with your co-parent and, if necessary, to help present your case to the judge in the most persuasive way possible. If you think that means you need Reed Law Group, we'd love to hear from you. Thanks for listening.